It's my privilege to welcome Lyrissa, who is a First Amendment expert and is the Raymond and Miriam Ehrlich Chair in U.S. Constitutional Law at the University of Florida's Levin College of Law. Thank you so much for joining us. We really look forward to your talk. Anyone who is not subscribed to the ISP newsletter yet, please write to heather.branch@yale.edu, and then you get notifications every Monday of our talks, both the Tuesday and Thursday. Over to you. Thank you so much.
Okay, well, as she said, I'm Lyrissa Lidsky, and some of you know me because you are working with me on the restatement project for the restatement of defamation, which I'm working on with Professor Robert Post. And it's very nice to be here. Some of you have the same con law professor I had, Jack Balkin, and I teach con law now, and I have some Balkinisms, I say. Does he still say, even if you don't like this kind of argument, you'll use it in practice, and so you need to know it? That's one of the Balkinisms I use in my own con law class. So this error today, that's a great way to start. This article that I'm going to be talking about today is about defamation by hallucination. And it's called Inevitable Errors, and as we'll see when we get to the end of the talk, that's a nod to New York Times versus Sullivan, which put in place the actual malice protections for journalism because journalists, if they're doing their jobs properly, will inevitably make errors. And so there was a necessity to tweak some of the common law of defamation to make sure and protect a medium of communication that is subject to inevitable errors. And we'll talk about how that might apply to generative AI. But just so you know, I'm writing with one of my students and research assistants, and he is doing a deep dive into all the alterations that are going on in generative AI. So we'll be absolutely up to date in our descriptions of some of that. Okay, so the framing case that we start with is a case called Walters versus OpenAI, and maybe you read about it. It was reported in all of these publications, some of which called me and some of my friends for quotes about Walters versus OpenAI. And the case came out of Georgia, and here's what happened. So Mr. Walters is a Second Amendment activist. And there was a journalist writing in the space about various kinds of Second Amendment issues, various kinds of gun rights issues. And so he was messing around with ChatGPT. And ChatGPT, he asked about this guy Walters, and ChatGPT told him that Walters had been accused of embezzlement. And he kept querying through his prompt about Walters, and it produced a false complaint, a complaint accusing him of embezzlement. It turned out it was an entire fabrication, what we know is a hallucination. And so it was the first American suit involving generative AI. And so one of the things I want to talk about is how do you apply, my whole topic is how do you apply old law to a new technology. And I know that a lot of you don't study defamation in any of your courses at Yale Law School. I know this because when we hire people to work on the restatement, a lot of you haven't had defamation. So I'm going to give you a bonus of this, not part of your tuition dollars, a bonus of this is that I'm going to give you enough to pass the bar on defamation right here and now. Okay, here you go, here you go. So the elements of defamation today, and this is kind of simplified because the elements turn out to be super complex depending on the identity of the plaintiff and the status of the speech. But you have to have a communication made by a defendant that is defamatory, false, a factual assertion. The communication has to identify the plaintiff, not by name necessarily, but it has to identify the plaintiff. And here's an element we're going to be talking about. You have to have publication to at least one third party. That's a term of art in defamation law. It doesn't mean publicity, and it doesn't mean what a publisher does, although there is some overlap there. But publication to at least one third party. And then fault amounting to at least negligence, but sometimes actual malice, depending. And damages, one of the unique things about defamation law is that damages are often presumed damages. In other words, the jury can award damages from the very nature of the statement itself. And damages are presumed in part because it's thought that reputational harm occurs in ways that are too evanescent or hard to prove. Like if you don't get invited to parties, how do you bring people to say, well, I was going to invite her, but then I read that story in the newspaper, now I'm not inviting her to parties. Or, you know, you're shunned or socially ostracized. That can be hard to prove. And so presumed damages are available in lots of, not all, but lots of different types of defamation cases. But sometimes you have to prove more. Sometimes you have to prove actual damages, which is a little bit more of a burden. And sometimes to recover, especially if it's a slander case that doesn't fall into a certain kind of category, you have to prove money damages, out-of-pocket losses, before you can get any other kinds of damages. Okay, so that was the simplified version of the elements of defamation. Here's the constitutional, super complicated version about status of the plaintiff, status of the speech. And you can see that it gets a lot hairier once you get into this, whether you have to prove actual malice in order to get availability of presumed and punitive damages. If you're a private figure, but it's only a matter of public or it is a matter of public concern, you have to prove negligence at least. But if you prove negligence, you don't get presumed or punitive damages. You have to show actual harm. And so maybe you want to go up to prove actual malice anyway, even if you don't have to, just to get bigger damages. And then there's some indication that common law courts can default back to strict liability if it's a purely private case, private figure matter, private concern. But I've just been on, and some of you went with me on this 50-state survey of fault, I've just been on a 50-state survey of fault, and not many have actually defaulted back to pure strict liability. And I will say, as of today, I can assert that with more authority, I think, than any lawyer in the country, because I've just read all 50 states and tried to assemble them. By next week, my knowledge will be obsolete, but as of today, there aren't very many. Okay. Now, one of the features of defamation law that becomes relevant to our inquiry is something called the republication rule. The republication rule. And here's what the republication rule says. It says, if you are a publisher and you repeat the defamatory statements of another person, you are liable as if you originated them. So if the New York Times calls me up and asks for a quote about, Trump's executive order, and I say something defamatory in the context of that executive order, I am liable for that, but so is the New York Times. They have responsibility. They are treated as the publisher of that statement. It constitutes a publication. Now, they might have other protection. There are ways that the republication rule gets modified. You can think of the actual malice rule as a way of modifying the harshness of the publication rule. But there's all kinds of privileges that have developed over time, and some come from constitutional law, some come from statutory law. CDA 230 is one of those, and some come from common law to ameliorate the harshness of treating the person who repeats defamatory statements as if they originated them. Okay, so how does one apply these elements to Walters? Okay, so you had a communication made by a defendant. So the ChatGPT made the communication for which you presume that the creator of ChatGPT is vicariously liable. It was defamatory. An accusation of extortion is classically defamatory. It's reputation damaging. It was completely false and fabricated. Is it a factual assertion? Now, ChatGPT is claiming, look, we put a disclaimer out there, and the disclaimer says that it's a known thing that we hallucinate sometimes, and so therefore you can't treat it as factual. Except for that's contrary to all of their promotion about use us for research, and we're going to revolutionize productivity, and we're going to, we're totally reliable, we're changing the world of work, we're diagnosing cancer. So the disclaimer doesn't necessarily negate their liability, although it might be relevant. Okay, you had identification of the plaintiff by name, so that's not a problem. You had, at least, there's an argument you had publication to at least one third party, the journalist named Ryle, who was doing the querying, and then he's the one that told Walters that he found this information about it. You had fault amounting to at least negligence on the part of the defendant. Wait a minute. how do you apply concepts of fault, whether negligence or actual malice? Walters is probably a limited purpose public figure for commentary on his Second Amendment activities. So how do you prove actual malice when it comes to ChatGPT, and what might substitute for the concept of fault? And we'll talk about that in just a second in this context. And then, are you going to presume damages in this case? If you have actual malice, you get presumed damages. And normally a jury might assume from an accusation of embezzlement, you could presume that that would seriously harm reputation. However, I want to point out something, and this is one of the problems with presumed damages, okay? Here's what was not reported in the Walters case. Here's what ChatGPT said along the way of producing the defamatory statements. I'm sorry, but as an AI language model, I don't have access to the internet and cannot read or retrieve any documents. Okay, so in the course of producing the complaint, the fabricated complaint, it says, I don't have access to the internet, can't produce documents. As an AI language model, I cannot verify the authenticity of any documents or claims. So, you know, the journalist is asking him, is this right? I cannot verify its authenticity. I apologize for any misinformation I may have provided earlier. I don't know if you've ever spent time, surely you have by now, spent time with ChatGPT. I couldn't remember the name of a case about, you'll know the case immediately, national security law, and it passed strict scrutiny, material support for terrorists. So I asked it, I'm like, what's the name of that case? And it gave me 3 cases. 2 of them were completely hallucinated. But I knew, Humanitarian Project versus Holder was the one that was not hallucinated. But anyway, I knew that the others were but then I told it, I said, no, those cases don't exist. And it said, I'm sorry. At least it's polite. Okay, so the structure of the article I'm writing, and really this is a tremendous work in progress. I thought I would be farther along, but the restatement's been taking too much time. And so the structure of what I'm working on is, the challenge is applying new technological means of defamation, this old law of defamation, and what do you do? What do you tweak to simultaneously protect reputation and also protect the ability of ChatGPT to continue innovating, and perhaps to innovate in ways that it gets better and better. Maybe there are fewer hallucinations, but as I'm going to show in this presentation, hallucinations do seem to be inevitable. And so what do we do when hallucinations are inevitable? How much breathing space do we want to give for innovation on the part of ChatGPT and other companies like ChatGPT when hallucinations are inevitable? And one of the things, Eugene Volokh, you may have read it, he wrote a really good article a couple of years ago called Large Language Models about this. But the problem with Eugene, there's not a problem with Eugene's article, but one of the issues of the reason there's still a need for an article in this space is that ChatGPT has changed tremendously since then. So the chain of reasoning or chain of thought aspect of ChatGPT, I'm going to show you in a minute, opens up new avenues for defamation. And the other thing about Eugene's article is it didn't take on this topic, what if hallucinations are not only inevitable, but valuable? And then, so I'm going to propose some things I've learned along the way doing the restatement, strangely enough, about the law of the telegraph and about defamation law as a tool to evoke communications policy. Defamation law has always been used for communications policy. It's always balanced protecting reputation against other values. And the thing I love about tort law, I've taught torts for a million years. I also teach common law. I teach torts, I teach advanced torts, media law, First Amendment law. And the thing I love about tort law is it's endlessly adaptable. Now, one of the weird things about defamation law in particular is tort law was going along as it does. It started its life as a sin in the Middle Ages in the ecclesiastical courts, right? You would do penance for defamation. And then there was a jurisdictional battle with the Lord's courts, the courts of the manor. And so they would give money damages. So that was the beginning of a tort-like remedy. And then defamation becomes a crime after the printing press comes along. So criticizing the king or the nobles is called scandalum magnatum. that becomes a crime. Very famously in the Court of Star Chamber, there were a lot of prosecutions. They might cut off your hand for that. By the way, I bring this up because who loves scandalum magnatum? Who loves it today? Who on the Supreme Court loves it? Who cites it as something we should go back to? Yes, Justice Thomas. Justice Thomas says we should get rid of the #1 precedent in all of First Amendment law, New York Times versus Sullivan, which brings in the actual malice rule. And we should go back and look at text history and tradition. And we should think about the law of scandalum magnatum. Even though I thought we got rid of kings in the American Revolution and like criticism of kings and a democracy has some issues, but not only Justice Thomas, but a Florida judge just this last week cited scandalum magnatum as something we should go back to. And there's a brief in the Supreme Court in Wynn versus Associated Press that also cites scandalum magnatum. And just, let me just say for the record, they need to do better history and more history if they think that that is where they should go. But anyway, I digress. What I was gonna say is, from the beginning, defamation law has always been able to adapt to protect what we think needs protecting as a matter of communications. But starting in 1964, it was complicated by the fact that the Supreme Court comes in and sets a constitutional floor, okay? So that complicates the ability sometimes of the common law to adapt because they can't, you know, adapt rules in contravention of constitutional principles, although usually it's just a floor. You can go higher and you can do more. And then, of course, the biggest two statutory changes to defamation law are the passage in many states of anti-SLAPP acts designed to get rid of meritless cases very early procedurally. And then the other one, of course, is Communications Decency Act, Section 230, which made the modern internet by carving out an immunity for defamation liability for user-generated content. But only for some, right? The New York Times still has liability for user-generated content. Okay, so one of the things that my research assistant and I have been looking at, this, he actually put this together, is at the time of the Walters complaint, the capacity of ChatGPT, what you could get into the context window to have analyzed, was about the size of the Declaration of Independence. And then, so the maximum output tokens was about the same. And then today, when Volokh wrote his article, it was bigger. And today, you can get all of Harry Potter and the Deathly Hallows into the context window and have it analyze it, and the output window is about the same. So the capacity of ChatGPT is increasing exponentially, and then DeepSeek is changing things as well, right? Because it's challenging. It could be that the development of these technologies is far cheaper than anybody envisioned, and so there may be many more competitors, and you know, the point is to say whatever law we're going to put in place, we need to be cognizant of the fact that it's in a period of tremendously rapid flux. And one of the things you've had since Walters did his claim is the emergence of reasoning models with what's called chains of thought reasoning. And chains of thought are designed to improve the reasoning of LLM models. And it used to be that the prompter would prompt the model to like go different places and compare different things to get better outputs. But now that's kind of built into the process of the model itself. OpenAI and DeepSeek are the first real reasoning models. And it really is a tremendously valuable thing because now you can see how it gets to the answers it gets to. But there's a problem. This is where the possibility of defamation gets magnified. Because this is a little experiment run by my RA. Okay, so he asked it about sexual harassment claims against law professors at various schools. And this is an early one. And actually, I'll tell you who that was. I blacked it out, but I'll tell you who it was, and I'll tell you why it made the mistake. It's Eric Posner. And the reason it made the mistake is Eric Posner, not that he's been accused of sexual harassment, he's written against sexual harassment a lot. And so it accuses him, but it's entirely false. But you can see in the chain of reasoning that there's some doubt about it, which makes you wonder, should you rely on that? And then here's some other ones. And this poor guy right here, I have no idea. There's nothing in any of our research that indicates why, how he should have been named. But he's ultimately not named in the output, right? He's named in the chain of reasoning, but he's not named in the output. So the chain of reasoning is supposed to be self-correcting so that the output is not incorrect. And so then there's the question of what if you as it's going through documents, it raises the possibility that you might have been guilty of sexual harassment, but then it corrects by the end. Okay, so there's a taxonomy of hallucinations, and hallucinations, I'm going to submit to you that some hallucinations are good. And if you've ever used like the AI on Lexis or the AI on CoCounsel, I don't know how you find it. I don't find it that useful. Okay, and part of the reason it's not that useful is it's just totally, it is designed to give you a source for everything, which is nice. Like sources are nice, I like them. And then you can verify what it's doing. But because it's that kind of closed universe, it doesn't have the creativity in helping you find something you didn't know you needed, right? So one form of hallucination is an output inconsistent with the user's prompt that may actually be highly creative or helpful, okay? And another kind is sometimes there are responses that are inconsistent with the training corpus of the LLM. And again, you can set LLMs with different temperature settings depending on how creative you want it to be, how outside the box you want it to operate in terms of pattern recognition. And so sometimes what's valuable about AI is the fact that it's creative, but it's also, the more creative, the more capable of hallucination it is. And along with those hallucinations comes the potentially harmful ones, the ones that are inconsistent with the facts of the world. Okay. So I've been reading computer science papers, at least to the extent I can, equations notwithstanding. And basically the computer science literature says hallucinations are in fact inevitable, that they're a product of incomplete knowledge, even though there's millions and millions of documents in some of these models, that the knowledge is still incomplete. The way they operate is probabilistic. What words go together, and words are broken into tokens, and then what tokens go together. And so it's a kind of pattern recognition that can go astray. A lack of human understanding of ambiguity in some senses. If you ask it about the word LEAD, are you talking about lead? Or are you talking about lead? And so it can make a mistake in interpreting ambiguity and interpreting what the user is really asking for. And so what do we do with that? So some current proposals have been, we need notice and takedown liability. Okay, we should treat it like copyright law, the DMCA, or we should treat it like Europe treats all kinds of information that they think is harmful, is we should have a notice and takedown system. Okay, now one of the problems that I think a notice and takedown system, one of the things I think we have to avoid is if you just straight up give a defamation action in cases like the Walters case, and it's still pending, it's been sent back, but it's still pending, is you will have attorneys sitting there at their computers just plugging in, with a phone book, plugging in people's names to try to produce a defamatory output and then calling up the person, hey, did you know you've been defamed online? I'll gladly represent you, okay? Or if you have takedowns based on this, you run the risk, and Eugene Volokh acknowledges this, that the experience of the DMCA says that sometimes you will have vastly over-inclusive takedown and an army of people getting things taken down that are bad for ultimately the use of the technology. They're bad for the technology as an investigative tool. In this case, there's no motivated watchdog for takedown. Like at least in the DMCA, you have the copyright owner with an incentive, a vested incentive. And here you don't have that. How am I doing on time? Not great. You're terrible, really, but I'm just going to keep going. And the other thing that Eugene he doesn't talk about is it's not clear that takedown is completely technologically feasible. I'm trying to get a computer science person to help me with this. I've talked to technologists, and he hedges on this. He knows it might not be completely technologically feasible, because here's the reason. Even the creators don't always know why hallucinations occur, because they occur due to multiple factors. And so just because it occurred once doesn't mean it's gonna occur again. And so just because that's the paranoia, right? That's why you think there ought to be liability, is if it occurs once, how many other people are searching my name and finding out I'm an embezzler and I don't even know about them? That would warrant damages. And so, but given the black box nature of hallucinations, it's not entirely clear that you can get them down, or at least that you can get them down without just ripping out all references to the person, which is somewhat problematic if we care about information quality and the quality of the technology. And then another proposal has been that we treat the issue like reasonable alternative design. Like we treat a hallucinating AI model like a defective product, okay? And we decide whether you designed it with too many hallucinations, potentially. But the problem is, how can the law move fast enough in this sphere to keep up with the chart I just showed you about the tremendous growth and change in the technology? And do we even have experts as to what's reasonable, and how do we adapt that? Let me go on to the next. Okay. So what would we want? If errors are inevitable, then what do we want to have happen? We want to encourage chain of thought development. And we've been talking about how the right advice for OpenAI right now would be shut it down. You can have chain of thought, but don't show the results. But don't we want them to show the results? Don't we want the model specifications? Isn't that good for ultimate innovation? And the thing is, the chain of reasoning is helping the ultimate output be more accurate, and helps you see where the reasoning can go awry. And so do we want that to be shut down by liability? We want to encourage feasible moderation, but we can't set a rule that encourages moderation that's just not possible. We'd like full transparency in model specs, just in terms of innovation and benefit to consumers. And we would like to discourage those tester cases and also prompter negligence. Okay, so the journalist who was asking the questions in Walters, it was a setup. He kept prompting it and kept prompting it and kept prompting it until he got something bad. Okay, and so we don't want to reward that kind of behavior. So what could we possibly do? So one of the things we might do, and it's not obvious, at least I don't think it's obvious, is we need to really think about our categories of publisher and distributor, and whether ChatGPT is more like the New York Times, and it's fair to hold it liable for this content that it originates, because that's what publishers do, or whether it's more like a distributor, more like a bookstore or a library, even though it is originating the content in some sense, it doesn't necessarily have the ability to control the output in some sense prior to, or the knowledge of the need to control the output before it is output. Okay, so here's the draft of what constitutes publication under the restatement third of torts. And this is just a tentative draft until it's approved by the ALI. It's not final yet. So look at what it says. It says a defendant publishes a defamatory statement when the defendant communicates the statement either intentionally or negligently with actual or imputed knowledge of its content to someone other than the plaintiff. Okay, so if you know the content, you're responsible for the content. And if I say so-and-so is a pedophile, I know the content of what I'm saying. I don't have to know it's defamatory. But the imputed knowledge is what we do to publishers. And it usually goes along with editorial control. Because you have the right to control the content, ability to control the content, knowledge of need to control the content, we impute knowledge of the content to you even if you don't have it in any individual case. And in effect, it creates a duty on those who initiate, develop, edit, select, prepare content. It creates a duty on them to take reasonable steps to make sure that what they publish is accurate. Okay, but here's the distributor rule. And I will confess right off the bat that it's not absolutely clear. And I wouldn't have said it was 2 years ago, I would have had a different take on this. It's not absolutely clear that you fall into the distributor category. So an actor who merely transmits, delivers, or makes available a defamatory communication to another is a distributor of that communication. A distributor does not publish a communication unless the distributor has reason to know of the content, has authority to edit the content, and fails to do so under circumstances that would give rise to ratification or adoption. Okay, so this is not notice and take down per se. It's notice and take down when failing to do so would mean that you're signing on to the content. And the reason this rule is written this way is to protect things like libraries. It's a policy choice. All of this is based on policy choices. And it anticipates things like if CDA 230 gets repealed, what should be the rule for internet service providers? So it anticipates them being treated as distributors, which they were starting to be before CDA 230 got passed. There was a dispute. Are they publishers? Are they distributors? Because they have some aspects of one, some aspects of the other. And so, but the question of which label you place on someone is a policy choice based on what you think, whether it's fair to make them responsible for all their content or not. And so I really have, the reason I know that we can decide what policy we want, and maybe we decide we don't want to protect ChatGPT that much, right? Maybe we do decide we don't want to protect them from liability that much. After all, you know, when the internet started, I'm old enough to have gone through the first cycle. You know, people thought, some people thought it was utopia. Some people thought it was the apocalypse. Right, I was more on the utopian side. You can probably guess that. I'm a sunny-eyed optimist who knew, but I was more on the utopian side. But it turned out, really, the reality is somewhere in the middle. It's neither utopia nor the apocalypse. Some people still think it's the apocalypse, but nobody thinks that about ChatGPT. Nobody's buying the it's gonna make everything better, and especially when it's Sam Altman selling it, I'm not buying it. Right? I'm really not buying utopia from that guy. However, it is the case that we still do need a range of protection for this new technology, and especially during the period before we fully understand all the ramifications of the liability choices we're making. And I will say what inspired me to do this, strangely enough, is the law of the telegraph. Okay, so when we started the restatement project, I declared very boldly to Robert, I declared, we're gonna go in and take all that stuff about telegraphs out of there. Because the last time the restatement was done, the defamation sections was 1977. And I'm like, no one wants to read about telegraphs, it's irrelevant. But I learned a lot researching the history of the telegraph and why it matters. And here's why it matters. Think about the way a telegraph worked. I come into you with my message, not this long because that'd be $1 million. I come into you with my message, you send the message, you have control over the message, right? Without you typing it in, it doesn't go. You have editorial control over the message. You get to type in what's put in. But early defamation cases threatened to ruin the viability of the telegraph as a revolutionary communications technology, which it was. And so the common law just developed a workaround. They completely developed at first they developed it as a privilege. It was an innocent dissemination privilege. So unless, you know, it said on its face something that was clearly defamatory, you weren't responsible for it. But then they built it into the prima facie case. So there was some suggestion that the plaintiff had to prove that you knew it was defamatory before you transmitted it, or you couldn't have liability for telegraph operators. And so my point here today is we can do what we want. And the question is notice and takedown, which is what's been proffered so far as an alternative to Scienter, which ChatGPT doesn't have, or a products liability type approach. But is that going to do enough? Is it even technologically feasible, which I think is as yet not clear cut? And do we want more protection to, at least in this interim period, while we're still, while the development is still going on this rapidly? All right, now I'll take questions. Yeah.
I'll have to run here soon, but this is amazing. Dean Lidsky, former Dean Lidsky, Professor Lidsky. So one.
If you call me a dean, I have to watch what I say, so you better call me professor. Although I'm still from Florida, so this is recorded.
I was gonna say, one observation and one question is, the observation is, and cards on the table, my partner works in the governor's office of California, so part of our portfolio is how do we regulate AI?
Yeah, yeah.
After ChatGPT came around, everybody was like, oh my God, what do we do about ChatGPT? This is horrible. And it seems like in Silicon Valley, there's this at the Google funded researcher, there's this kind of Section 230 shadow. It's everybody has grown up in the world of Section 230, and the people building the technologies and researching them, they just assume that there should be some outsized protection against liability so that we can move as quickly as possible.
Yeah.
It feels like that's just a drag on every part of how we regulate AI. Where just the shadow of 230 is looms. But the other question I had is, so have you all talked about a potential third option? So you have distributors, you have publishers, but there's also the idea of agents and defamation law. And if you're a lawyer and you were talking back and forth, that's not defamation because you're not, it's a privileged contact.
Right.
What about the idea of AI as just an idiot agent? This doesn't fully work because the agent is shared by maybe you already talked about this. And so the idea is if you tie liability not to the conversation between the AI and the user, but you tie it to
to the intermediary, because the problem here, I'm glad you opened that up. So one of the things I think that you have to do is place some responsibility on the person prompting. And it seems a little strange because we wouldn't normally treat it like that. But the reason I have in my prior slide, if I can go back to it, the reason I have a haystack here is, anyone remember from first year torts a case with a haystack? It's the greatest case of all time. It's not the greatest of all times. That would be the flaming rat case for torts. But
was it Bobby Menlove, the one where his hay was going to catch on fire and he said he'll risk it?
Yes, exactly. In Vaughn v. Menlove, this guy moves to the country. I always call him Vern in my head. He moves to the country, and his neighbors say, you can't pile your hay up like that because it'll spontaneously combust. And he's like, I'm insured, I'll risk it. And then when, of course, it catches on fire and burns some stuff of his neighbors and they sue him for it, he's like, you got to understand, I was dumber than the average bear. I can't behave like the reasonable person because I'm not that bright. And I'm like, Green Acres, I came here from afar. And anyway, greatest case of all time. But if you're going to be the prompter, like the guy, Real or Ryle in the Walters case, you don't get to be oblivious to how ChatGPT works and not verify your outputs such that it creates harm to others. And maybe you should even be treated as an independent intervening cause in a lot of instances, because you could have stopped the harm right there. Already we have cases that say lawyers are negligent if they just use ChatGPT output and put them into courts. There's lawyers already getting whacked by judges for doing that. Journalists, there is no doubt in my mind that a journalist would be liable that it would be actual malice if you just relied straight up on ChatGPT output without further investigation. You just published it. You're going to be liable for that. And so maybe, and I call this, in tort terms, this is the least cost avoider. Maybe placing more responsibility on the prompter to verify is the least cost avoider. Now you might say, well, okay, Ryle knew better. What about the 5 other people that searched for Walter's name and it's put the same output? I don't know if we have evidence that it did do the same output based on what we know about hallucinations and how they work. But, you know, maybe you should have access to the logs of who searched you and what it did output about you. By the way, it thinks I went to the University of North Carolina to law school. Not defamatory to say you went to UNC. Not correct in my case, but not defamatory either. Yes.
Thank you. Thank you for the wonderful presentation. I was told when I audited torts that they're going to start teaching defamation in your law school next year, so.
Oh,
Yeah.
yay, yay. This is good. It's good for, wait, how many of you are working on, anybody in here working, restatement folks? Okay, yeah. This is really good for the restatement.
I thought you would be happy.
Yes.
So I'm going to ask a slightly, I was also a utopian. I'm now distinctly not. For
I'm not either, not really.
And so if I can push the least cost avoider
Yeah.
thing a little more and ask, I mean, maybe it's too late, but I wonder whether it makes sense to also think of a case in which anyone that releases a model to the world before they've worked out how to put,
Yeah.
guardrails aren't possible right now.
Yeah.
I'm wondering why those solutions haven't been thought through. So I was reading about this, it was not DeepSeek, one of the Chinese companies developed the model and then only released it to businesses. So that's kind of one way, because
Yeah.
it's only being released to people that can take the liability. And so I'm curious, especially after what's happened with the social media platforms, I'm curious about why we're all treating it like it's inevitable.
That's true. No, it's a good question is we don't have to have this thing at all. We could just say no. We don't even want it.
Or we do, but more carefully, like.
Right, or we want it to roll out slowly. And you're right, we could roll out to limited audiences. I mean, one of the issues here is if we do impose liability generally, that would cause the companies to retreat to putting out to limited audiences who are still going to be, they would be like the learned intermediaries. They're still going to be receiving hallucinations, but we could trust them to like not do bad things with the hallucinations, right? Because they understand how the model works. And so maybe that is a potential solution. I just think that the problem then is, I mean, they would be the ones with the visible chain of reasoning, right? So only the rich people get the good stuff that actually produces good outputs. And we get the constrained stuff that's kind of like the you know, the garbagey GPT that Westlaw gives you. I mean, but you're right, it would be a choice, and there are some attractions to that choice. Like, I truly haven't landed for sure on the perfect solution. I just think, you know, I just want to think through whether notice and takedown is really correct or not. And it really is hard for all the reasons you said. Yeah.
So this one might be a bit tangential, but I was playing around with ChatGPT yesterday, and I noticed that it gave me an option to edit the answer that it was giving me. This was ChatGPT 4.
Yeah.
So I was wondering if there's any, I mean, obviously it's not gonna happen, but I was wondering if there's any potential for like a collaborative option on this one, like Wikipedia, you know?
I mean, that's where we've gone on X, is like community notes, and that's where we've gone on Facebook. That wouldn't, like, typically that wouldn't protect you from defamation liability, because even if you say, you know, people are saying that Lidsky's a pedophile, I always use, until the Drake case, I always use pedophile as an example of something that is clear-cut defamatory. And I talked through that one with my class yesterday, and it turns out even pedophile can have some contextual meaning that's a little bit different than the literal meaning. But normally that wouldn't fix it in defamation law to say people are saying he's a pedophile, but I don't believe it. You'd still be liable as if you said the person's a pedophile. And so, but maybe we're gonna have to bend some of that to put up with imperfect outputs. The reason the article's called what it is this, from New York Times versus Sullivan, is the idea that you need some breathing space to allow for the fact that sometimes errors are inevitable, And the breathing space we carved out there is negligent errors we'll tolerate. Negligent journalism will tolerate that. We won't tolerate lies, and we won't tolerate reckless disregard for the truth. But the idea is they have incentives to get it right. I guess part of the question here is, does ChatGPT have enough incentives to get it right that it's fair to give them a break? Are there incentives for accuracy in the long run high enough that we can trust market forces in the absence of liability? What do y'all think? Yeah.
I think I'm with you. I'm a tort purist. Like, I think if we let the tort system process the cases, we're gonna get to the right place.
Yeah, yeah. I'd rather do it with tort than legislation.
On either side.
Yeah,
And we're not protecting them.
yeah.
Because the courts are gonna, I mean, we and juries are gonna like award billions of dollars to people who are really harmed by ChatGPT and will set the incentive structure. It just means people will get hurt in the short term.
Yeah, well, that's the other thing, is one of the problems with defamation law generally, and, you know, I've written about this, my whole career has been writing about this, is weaponization of defamation law and using it to punish your critics, because it's really easy to bring a defamation suit anytime you're criticized. And if you have enough money, you know, you can inflict a lot of pain on a person, even if you're not ultimately gonna win. And now what you have going on is you have the mainstream media is extremely unpopular, and because you have this doctrine of presumed damages not necessarily tied to any real harm, like normally in torts, you've got some real harm, even if you got pain and suffering damages, you're anchoring that to physical injury, which is a real harm, or things like your medical expenses, or things like your lost wages. But here, you know, it's what the jury feels like giving in certain instances, and especially if you don't like the actor who's putting out the information and you think they're sloppy, you think they're purveyors of fake news. And so could you make sure it's not devastating by limiting the damages in some respect, and let Mr. Walters recover if he can actually show that he suffered any real reputational damage other than by suing, right? Because that's the Streisand effect. How do I know Walters was accused of embezzlement? Because he sued for defamation. Yeah.
Can you say more what work that typology is doing in your argument?
You know, it's not fully tied yet, but right now all the work it's doing is showing that that errors are inevitable, and that errors are tied to a valuable facet of ChatGPT, one that you want to foster to a certain degree. I mean, it's a balance, right, between the creativity of ChatGPT and the errors of ChatGPT. And if you try to eliminate all errors, you'll eliminate the value of the technology. But I want to see if I can, and I've been reading the computer science stuff, find ways to limit the type 3 errors, right? To maximize the other types while limiting the type 3 error. And there's some indication chain of reasoning can help that. And so chain of reasoning in particular, I don't want to say you've got to hide the chain of reasoning or you've got to shut it down, because it's more likely to produce the more valuable outputs. But that taxonomy was just written, that article, I believe, was written by a couple of Yale computer science folks. It just came out in the fall, and I wanted to do something with it.
Yeah, that was my.
I think it can do more. I just, you know, that part's not written yet, but I think there's potential for even more, but I've got to dig deeper into the computer science literature. Yeah.
Yes, my name is Anna, I'm a fellow at the USP. Thank you very much for submerging to American defamation law. I'm from the Netherlands originally. So to go back to your last question about market function versus legislation, I'm a civil law jurisdiction.
Yeah.
So we don't have the luxury of working with torts. So I'm wondering without going into a whole different legal system, what's your perspective on countries that have to deal with similar challenges that don't have the common law perspective on this, right? So it has to be a bit more I would say anticipatory in a sense.
That's true, and it's gonna be some kind of legislative fix, and the other thing that you have the potential for is these kind of commissions. So the closest thing we have to something like that is something like a restatement project, but you have harmonization commissions to make all of the laws fit together, and then you have like commissions of like just great minds getting together to try to decide where the law should go on an anticipatory basis. And the restatement does that a little bit, but it's not supposed to really do that. It's really supposed to partly be backward looking, but partly anticipate how the principles can apply going forward. You can see that that formulation of the distributor rule is a forward-looking anticipatory thing. I think it's harder. And particularly if, you can't revise like once you get a rule in place, if it turns out to be out of step, or if it turns out to stymie innovation, how do you ever get rid of it so that you can be, internationally competitive?
Yeah.
The other thing is the rules you choose affect what technology companies do, no matter what the US does. So some of the notice and takedown regime affects what technology companies do even in the US right now.
If I can ask one short follow-up question. So to come back at the fact that you also mentioned that like the technological feasibility of like tracing and that whole thought structure. In the new European AI Act, it says that certain algorithms with major societal impact, that their result must be traceable and explainable.
Yes.
I'm not an expert on the AI Act, but that seems like something, from what I hear, is not very realistic almost.
That's interesting. So traceable and explainable, that might actually be counterintuitively create more potential avenues for defamation. Like I also agree it should be traceable and explainable, and I think the chain of thought or chain of reasoning helps make it more traceable and explainable, but that is itself an avenue for defamation. And so I don't know if they've thought through, that there might be more harmful content emerging because of that aspect. But I've got to go track that down. That's fascinating.
Thank you very much.
I mean, we talk about transparency as a unmitigated good, right? Is transparency always an unmitigated good? Yeah.
Yeah, I'm sorry, this is just gonna be another wrinkle and probably not helpful.
No, it's good. Like I say, this is very much a work in progress, and I'm very much like, is the place I've landed the right place?
Yeah, something that I've been thinking about is I'm in an AI reading group right now, and we read a piece early on about the fact that chain of thought reasoning is often not nearly as faithful as it appears. And so there are certain tasks that it's very useful for, and that small models tend to be more faithful than large models. But it might be worth it, especially if you're considering potentially raising the bar for liability for people who are providing prompts, or thinking about split liability between model and creators versus somebody who's entering a prompt, whether the fact that the chain of thought reasoning is often happening sort of post hoc and it is not necessarily representing what the model is doing, how that plays into who we think deserves to be blamed for what.
That's
and then
nice.
Whether that's changing over time as well, I don't know, but maybe it's actually sort of a model specific or even a question specific type of liability if it's genuinely that there are certain problems where chain of thought is going to be faithful to what's happening, and then certain questions where it won't.
That's very interesting. Any chance you could send me the article?
Yeah, you got it.
It's just in case anybody wants to send me any article.
So one really basic question and then maybe a more interesting one. The really basic one, am I understanding correct if we're talking about thinking of AI platforms as distributors rather than publishers? There would be no one who would hold the traditional publisher role. And the other question that I have is that a lot of this seems to assume an AI company that wants to not commit defamation. When I
Yes,
think about something like, say, Grow, which sort of advertises itself as like a deliberately like anti-woke platform.
Yeah.
Like purposely trying to put out what it sees as like maybe politically extreme content. I'm just wondering if you have sort of a regime in which this sort of the liability is on the user for having kept generating their content, but the platform was purposely constructed to maybe like put out content that looks defamatory. How do we deal with sort of an actor in the market that's purposely putting out content using an LLM that's sort of designed to be defamatory?
I mean, one thing is we could tailor it case by case based on their actions that they either fall, which is actually what led us to the passage of CDA 230 is, y'all know the history of that, right? That there was a bulletin board that was moderated and one that was unmoderated. The moderated one got called a publisher and therefore was subject to publisher liability, and the unmoderated one was called a distributor, and Congress was like, wait, that's setting a perverse incentive. Maybe you reward the ones that are taking maybe it's, you call them distributors as long as they're taking steps to produce maximum accuracy consistently with, the need for enough creativity in the model. Maybe you only call those distributors. That might be one way you could cut it. Or maybe the nice thing is if it were purely a matter of torts, maybe you do it as a privilege, and privileges are pure public policy tools, and you lose a privilege through abuse. So, innocent dissemination, you lose the privileges if you're not an innocent disseminator. Or abusive privilege is usually lost by spreading it to, more people than you're supposed to spread it to. Right? If it's a job reference and you spread it to the world at large as opposed to just the new employer. But I think you could tailor it. I mean, the nice thing about torts is you can go case by case. The bad thing about torts is then it becomes unpredictable what your liability will be in any given case, because what if you're deemed a distributor in one case and not a distributor in the next case? So it would have to be on some fairly stable set of factors that would tell you how to set up with the proper incentives for accuracy so you could take advantage of the distributor rule.
This is technically a technical question. I love this entire presentation, thank you, because I did 2 talks on the Bull of Cardiff. It never occurred to me to question his recommendation that he had the first notice, you're allowed 1 error and then.
Yeah.
But this is fascinating because you've shown that 1 is that error might be user created, but 2 also that there may be no way actually figuring out how to avoid a second error. I'm just wondering, so in this computation of what you're saying, right? Where does the liability rest? How much care has the company taken?
Right.
Are you seeing anything in the technical literature that's addressing the problem of who knows what they're up to? I say this because I used to work so much on social media platforms.
Yeah.
And for years, there was this debate about, are they doing as much about hate speech as they can? And it's
Right.
only when the Haugen disclosures took place that everyone realized that no, they were aware. They just chose not to do anything about it.
Yeah.
I'm just how do you think law can deal with that learning? Or
that's the question is, how do you set a rule now that not only looks at what they're capable of editing now or capable of doing now, but also forces them to develop capabilities for feasible moderation. Like if you set the rule wrong, they don't have any incentives to start feasible moderation to protect reputation. So how do you set the rule, you toggle it at the right place, given that and also that we're lawyers trying to figure out what these technologies really can do, which is hard to know, right? And there, in the communications, I'm having trouble finding out, I need a computer science co-author right now. I've been reaching out to people to try to help me with the hallucination issues. Yes.
Frederick Cooper, who's at Yale right now, I'll send you the email. He's just been hired by Yale Computer Science. And he's super interested in law and policy, and he's really smart.
Oh, that would be great. because I want it grounded in something instead of just being speculative. I mean, too often in law, and this is a problem with law adapting to technology, right? And my views are informed by watching it over the last 30 years, right? When I was in law school, they didn't teach internet law. It was too early. I went to law school in 1990. A few law schools were starting to do something like that, but mine wasn't there yet. And so the class that I teach sometimes did not exist. And so I watched, all the utopian theory and all the apocalypse theory. And then, we can't regulate them at all. Well, yeah, we can regulate them. We're going to ruin them if we regulate them, which is, you don't want to make that mistake again. But if you're too heavy-handed in regulating them, then you'll stymie innovation. There is something to the argument. Can we do better this? I mean, it's really your question. Can we do better this time if we get experts who combine together, who've already been through or already learned the lesson? You don't have to have been through it. Already learned the lessons of the last technological wave. Can we do better somehow? But I don't think lawyers alone can do it. Yeah.
Yeah, I was wondering, John, before he left, was talking about the developers kind of operating under this assumption that they're covered by 230.
Yeah.
I was just curious if you have thoughts on how that will or should.
You might think I would think 230 covers it just because if I say they should be treated like distributors, it kind of goes together because 230 is saying you're not responsible for the content of others. But if you originate your own content, you are. And so I'm saying for distributor purposes, they may not be treated as originators in the sense that they don't know in advance what the content is going to be. And yet they are originators. You're not a mere conduit for the content of others. And so I really don't, I just think that based on the reading of statutory language, 230 doesn't protect them here. But that has to all be worked out. I've seen people argue that it does. I just don't think it does. But it's a related kind of thing is what do we want to brand them? They're not a pure conduit, but they're not a newspaper either. They're a pattern recognition organ that combines the content of others to produce new content without scienter.
Thank you. This has been fascinating. Thank you, Professor.